Payne versus Western and Atlantic Railroad Company, 1884. Payne was a merchant who sold consumer goods in Tennessee. He filed suit against the Western and Atlantic Railroad, alleging that the company had distributed a flyer saying any worker who trades with L. Payne from this date will be discharged. Payne stated that this action ruined his business. However, the Tennessee Supreme Court ruled in favor of Western and Atlantic, stating, all may dismiss their employees at will for a good cause, for no cause, or even for cause morally wrong, without thereby being guilty of a legal wrong. Although the dissenting judges in this case issued a strong warning that this doctrine exerted an unfair amount of control over employees, the court also said it is a right which an employee may exercise in the same way, to the same extent, for the same cause or want of cause as their employer. The Payne case established at-will employment as a viable doctrine, and the rule became known as employment at will, which quickly became the standard in U.S. employment law. Less than 25 years later, the U.S. Supreme Court discussed the doctrine of employment at will in the case of Adair versus U.S. 1908. Adair was an employer who fired an employee for joining a union, and they were prosecuted for violating a federal statute affording railroad workers the right to join and form labor unions. The Supreme Court favored Adair, saying that Congress had no constitutional power to regulate employment. This decision left the interpretation of employment at will up to individual states and helped to solidify it as a legitimate practice. Today, the employment at will doctrine applies to up to 75% of U.S. employees, and judicial and statutory exceptions have been developed to protect employees from being wrongfully discharged. Judicial exceptions, including public policy and implied contracts, resulted from case decisions in various states. Statutory exceptions result from federal and state laws that employers must obey. Therefore, to file a claim of wrongful discharge against an employer, a plaintiff must be able to identify a clear breach of an exception to employment at will.